Draper? I did. Okay. Oh, yeah. Seated.
Good morning, Your Honor. Calling the Commonwealth versus Philip Chism, docket number 2013-1446, 2013-1447, 2014-109. Scheduled for a status on competency. The parties please identify themselves for the record.
Good morning, Your Honor. Kate McDougall for the Commonwealth, with me is Assistant District Attorney Melissa Woodard.
Ms. McDougall, Ms. Woodard, good morning.
Denise Regan, Susan Oker, John Osler, and Mr. Chisholm.
Okay, Ms. Regan and Ms. Oker, and Mr. Chisholm and Mr. Osler, good morning. Okay, I've read through the report in detail from Dr. Merritt, that reads 67 pages. Does the Commonwealth wish to be heard further on that issue?
No, Your Honor.
And Ms. Regan, does the defense wish to be heard further on that issue?
No, Your Honor.
Okay. Based on having read the report the court finds that Mr. Chism has sufficient present ability to consult with his attorney with a reasonable degree of rational understanding and a rational as well as factual understanding of the proceedings against him. Short, he has the capacity to understand the process and the ability to function in that process. All right, Ms. Regan, there were a number of motions that you had filed, and I think the place to start, considering the motions, would be the renewed motion for a change of venue. Here you are.
Your Honor, I have compiled the broadcast media and the press media in the Boston media market concerning the publicity that has occurred since October 13th, 2015. In particular, the defense is concerned that the statements of the prosecutor that were reported about Mr. Chism, if I could have a moment, concerns that Mr. Chism was going to hold hostage the court for the next 4 to 6 weeks, that everything that's happened in the last 24 hours is not real, it's fake, that Mr. Chism is manipulating us, that the Commonwealth's fears had come to fruition. Your Honor, the reports of this are, I would suggest, are gratuitous. These comments that are reported are gratuitous and inflammatory material that increases the risk of prejudice to Mr. Chism. Further, I note for the court that the extensive publicity around the anniversary of the offense further increased the risk of undue sympathy and prejudice. So I would urge the court to move this case to a county outside the Boston media market so that the defendant could be assured of a fair trial.
Okay, thank you. Ms. McDougall, would you wish to be heard?
Briefly, Your Honor. Your Honor, I would initially suggest that the comments that the defense refers to by the prosecution were not inflammatory or egregious. They were factual. The Commonwealth certainly is entitled to advocate for its position, a position which is in no way, well, I'll leave it at that. The Commonwealth is entitled to advocate for its position, and I would respectfully submit that the report that was submitted yesterday certainly does nothing to suggest there was anything egregious or in bad faith about the Commonwealth's position. To the contrary, the media coverage in this case, the lion's share of it was now almost 20 days ago. Certainly, I would suggest that what has been picked out by the defense in their motion is a little bit unrepresentative of what was actually reported, that the vast majority of the reporting focused on the defendant's alleged symptoms, the defendant's alleged conduct, and if anything was favorable to what the Commonwealth anticipates the defense will be, that the Commonwealth statements were in every article, in every news clip, only a very small portion of what was depicted. Nothing in the defendant's motion suggests that the process we had been using would not ferret out those people whose opinions have been changed. And I would just say respectfully with respect to the anniversary, the reporting on the anniversary, the celebration of the anniversary was very careful and cautious not to in any way, shape, or form touch on the defendant's guilt or innocence. It was truly about a celebration of the victim, and that was the only effort that was made, and it was very carefully done. And as the court has noted in the prior ruling, the mere fact that people are remembering Colleen Ritzer does not in any way prejudice the defendant any more than Boston Strong suggested that Mr. Zarnaev was more guilty than innocent. The Commonwealth has been very cautious for the last 2 years about, frankly, has at times been hamstrung in how it has advocated for this case in an effort not to sensationalize. The family has walked on eggshells to very carefully honor and celebrate their daughter in a way that doesn't prejudice the jury pool, and I would suggest that the motion should be denied.
Okay. Thank you very much, Ms. McDougall. Well, first of all, if the case requires a change of venue, then there'll be a change in venue. I indicated in my decision on denying the request for a change of venue that it was without prejudice. and everything that's happened since the impanelment stopped is important and will be considered. But at this point in time, the way I'm going to approach it will be to address the exposure of potential jurors to information. Now, there's another motion to start the impanelment anew. So I'll get to that in a moment. Let me just say this. If the court denies that motion, I'll do a thorough inquiry, obviously, of the seated jurors and jurors who are not excused for cause based on the questionnaire relative to their exposure to any information about this case. I have to say, it's been my impression, though, in the press coverage and in reviewing the questionnaires. First of all, the press coverage, it seems to me, has been factual in nature. And what struck me about the questionnaires was how little information most of the jurors had about the case. There were suggested questions from counsel. The defense asked me to phrase a question about having heard anything from anybody about the case, any statements anybody made. I thought that was a very helpful request from defense counsel. And I pressed the prospective jurors about the issue and about whether they knew anything beyond what was in the questionnaire. We'll have all the questionnaires marked for identification. But what struck me about the prospective jurors and about the questionnaires and about the responses on the witness stand and prospective jurors is that those people who had information that would get in the way of them being indifferent provided that information. They were excused for cause. That a good amount of people hadn't heard about the case, and many people who had didn't really have information beyond what was in the summary that counsel put together for the purposes of the questionnaire and the court evidence. Now, we may have a completely different situation. Situation may be different. Ms. Regan, you may be right about the information that the 16 jurors who were indifferent, who were in the box have, and those who would be inquired of, who have filled out questionnaires. And you may be wrong, but we have to find out. I think we have to find out. There is not enough on this record for the change of venue motion to be allowed, and certainly from the experience the court had during the days of impanelment, there's not enough for a change of venue motion. I'll end where I started by saying that if there has to be a change of venue, there has to be a change of venue. Difficulty and inconvenience aren't factors that the court considers on that. But I have nothing on this record now that requires a change of venue. So your objection is noted to that. My ruling is without prejudice. But if neither counsel has anything to add, I think the next motion has to do with the issue of whether or not to begin impanelment anew and dismiss the venari, the 16 prospective jurors in the box who've been found indifferent, and all the prospective jurors who have filled out questionnaires, or whether we should proceed and see what happens. I'll hear from you on that if you'd like to add anything to your written motion, Ms. Regan.
Your Honor, I rely on my written motion, but I would state that I attached a little description of Facebook news feeds, and as I understand it, a person checking their Facebook page, things that their friends that they're linked to will automatically, if it's not turned off, pop up on their screen of their Facebook page, and it be the headlines of the news articles or whatever that people like. And with Twitter too, the prospective juror doesn't have control necessarily of what's incoming. So, and given the publicity that I have documented and provided to the court in my other motion, and the nature of that publicity, I would urge I just also state the jury has been out now, the potential jurors, without coming to court for 3 weeks. And that is a long time for them to know the case that they're going to be on, the nature of the case, for there to be this atmosphere of publicity. And I would suggest the safest thing would be to start a panel anew.
And we may find that is true, we may find that that's not true. Certainly when English barons demanded from the king the right to trial by jury in running in England, they weren't dealing with Facebook, and they weren't dealing with Twitter, and they weren't dealing with social media. Those issues that you just raised are issues that the court has to address every day with whatever jury we have, whether it's from this pool that we've started to impanel from, or otherwise. I find that during my experience, that jurors are incredibly conscientious and serious. And we had them leave not only with the court instructing the jury to avoid any information, but I gave them an order, a written order, so that they would be able to show people that they were not allowed to talk about the case or observe any information. Now, some people are going to come in and have heard something. I would be very surprised if all of these jurors, despite their best efforts, didn't hear something. They cannot control other people. The examples you gave are some of the reasons that they can't control other people. And the question is going to be, with those jurors who had heard something, whether that impacts their impartiality, and if it does, they'll be excused for cause. If this becomes an exercise in futility, because of the period of time, changes in hardship, the schedule is different now, what prospective jurors have learned, then I have no intention in engaging in an exercise in futility, and we'll have to begin anew. Maybe that's the case. But my sense is that jurors never cease to amaze me with their seriousness, and that they seem to get it. They seem to understand how important what they're doing is. It may be that the time period has just been too long, that despite their best efforts, that they are able to remain indifferent. There's another issue as well, and I want to address that because it goes to the issue of the jurors that we have in the box and who have filled out questionnaires. And that's an issue of scheduling, because even if jurors have not heard anything, or what they've heard allows them to remain indifferent, there may be hardship issues as well. So before I get to scheduling, Ms. McDougall, did you want to add anything as to the Benari and the prospective jurors who are in the box and been found indifferent?
No, Your Honor, except to say I think the Commonwealth may be looking to supplement the record with some additional articles. I think this is really misleading and suggesting that the lion's share of the coverage was about the Commonwealth statements versus the defendant's symptoms, the testimony of Dr. McMillan, as well as the defense statements. So I'm concerned about the state of the record at this point based on the defense filings, but I certainly would echo the court's comments and point out that in some ways we are in an advantage. We have 80 jurors who were under written court order not to follow the news, as opposed to anyone who didn't even
helps move things along, not just more efficiently, but more fairly to both sides. So we were moving along at what I consider to be at a pretty good pace. So I don't know what counsel's estimate of when we'd have a jury would be. My plan would be to the extent that jurors are available from other courts or other days, to have them called in for Monday and Tuesday so that we have a bigger pool. Jurors who might not be used in Lawrence, jurors who are here tomorrow who would be called in for Monday, so we can have a bigger pool once we exhaust all the jurors we have.
Your Honor, I'm only standing because it's a time-sensitive issue. I don't know what the status is of the jurors in Lawrence next week. We had been told there would be no jurors in Lawrence next week because of what the courthouse is being used for, so I don't know if they were called off, and I'm only standing now because it may make sense to have conversation with Lawrence now in the event that's something that might happen today.
Doherty, could you just go check with the jury pool officer in Lawrence right away?
I'll do that right now, Your Honor.
Thank you very much. So in other words, I think we can get a lot of jurors and continue that process through after we finish with the jurors who have filled out questionnaires. So based on how well we were doing and moving along, what I thought ahead of schedule, I think that we could have a jury on November 16th, if not earlier. So I see this as opening statements on as early as November 13th, but cautiously November 16th. I want to get into the weeds a little on scheduling. I don't think it makes sense to sit the Wednesday before Thanksgiving and the Friday after Thanksgiving. I realize counsel will be working full days and the court will certainly be working full days, but it'll be impossible to get a jury if we expect them to be here the Wednesday and before and the Friday after Thanksgiving, so we wouldn't be sitting those days. The only day that I have that's a concern, a couple of programs where I might have to stop at 12:15 on a day or two, but the only day that I have that's a potential down day, and I'm only going to say potential down day, is December 4th. So I'm not holding I won't go through the long comment I made last time. I'll just say it kosher. I'm not holding the Commonwealth or the defendant to the schedule that you give me right now. I just want to get a sense of where we think we are with the jury, telling the jury when we think they get the case with that schedule. And I'd obviously add some days out of caution to that. So, Ms. McDougall, I know that it's impossible for you to say anything with precision here. What's your rough estimate?
My rough estimate is that the Commonwealth would rest its case in chief roughly December 3rd, potentially the 5th. I just don't know what scheduling issues I'll run into with witnesses those 2 days of Thanksgiving week. I know that my witnesses are all pretty available. I've already obviously vetted this with them. If the defense case was the week of the 7th, which I believe still works with their expert, then I anticipate we would rest and close after rebuttal sometime the week of December 14th.
Okay. Mrs. McDougall, Thank you. Ms. Regan, do you have a significantly different view of that?
I don't, but I'm very worried about the availability of my expert. He's not available at all the week of December 14th. I'll get an affidavit from him. But my understanding, he's been hired, this has been long planned, for the Department of Justice, by the Department of Justice to conduct a site visit in a prison and then report to a federal court at a hearing at the end of that week of the 14th. So I am, if the Commonwealth's case takes till the 4th, then that's awfully tight because, particularly because, one, under the rules of evidence, I would like to call him later in the case because I would like to put things into evidence that will make it easier for me to put in his testimony.
Well, I'm reticent to take things to Bene anyway in this situation, so I understand that.
So, and then the other thing is that the way this type of case goes in, of course I called Dr. Dudley at the end of my case, and then the Commonwealth calls their experts, and there is a possibility I would need to call Dr. Dudley in rebuttal. I don't know that. He certainly is the kingpin of the defense's case. He's the person that gives the opinion that Mr. Chism lacks criminal responsibility. So I'm very concerned because of the concerns about competency, the necessity for possibly shorter days, the fact that Dr. Dudley is not available that week. This was not foreseen. I mean, he has made himself available all the way up till then, and I'm sorry this is the situation.
All right, well, I'm not going to search for a problem. I have a feeling that there would be cooperation from another sovereign. That's my first thought. That it'd be considering where we would be on the case, I expect that the other sovereign that needs Dr. Dudley will cooperate. It also may be that there might be a couple of down days. My concern, obviously, for jury impanelment is that I can safely tell the jurors that the case will be to them before the week of Christmas. That's obviously what I want to be able to say to them. It seems like we are going to meet that quite easily, but we're going to have a lot of prospective jurors who are going to have hardship issues if it's otherwise.
Your Honor, if the Commonwealth case takes to December 4th, that only allows me 1 week to get Dr. Dudley's testimony in, and I'm really concerned about it. We have a lot of defense witnesses to call. This is not the usual type of case where the defendant has a list of witnesses and then doesn't call them. There are people from out of state. There are people concerning another incident. There are experts. There are students, possibly, and other people that are on the defense list, almost all of which need to testify, practically speaking, before Dr. Dudley. So I'm just advising the court of this. That's the situation.
All right. Well, I guess before I ask you your worst-case scenario, Ms. Regan, because I like to give prospective jurors not the best-case scenario, but the worst-case scenario. Before I ask you the worst-case scenario, certainly any witness upon which the expert's going to rely for the opinion, it makes sense to call before that. As a matter of fact, the defendant has to call that witness before the expert unless the court allows that part of the opinion to be admitted to bene, subject to the basis coming in later. So I'm really not trying to have a discussion about evidence issues. I'm really trying to have a discussion about what the worst case scenario is to tell prospective jurors. That's my point. And I'm not really trying to put myself in a position where I'm going to eat my words, but we're not going to have a situation, in my view, where a federal court is going to say, don't worry about the last 7 weeks of trial, we want him here on day X. I just don't think that's the way the world works.
I haven't had good experiences with
I'm just telling you.
There's a reason I'm in the state system.
I'm just telling you, I might be eating those words. I don't think I will. I think we will get the cooperation that we need. But I asked you for your worst case scenario, so give me your worst case scenario.
Well, unfortunately, if Dr. Dudley doesn't testify until December 21st, if we don't get the cooperation from the feds, then my worst case scenario probably is December 29th or 30th.
Well, I think what I will, I find that to be unrealistic. However, caution is the best way to go. And what I would probably do in that case, I like to have counsel have time to think these things through. What I'd probably do in that situation is, as cumbersome as it is, and you're adding 2 more people who need to follow the court orders, I might well stick with 18 jurors instead of 16. And I'd probably tell them that we'd expect to get the case to you before the week of Christmas, but anything is possible. The thing about one of the examples of how jurors rise to the occasion is trial after trial after trial. For 18 years I've been a judge. We impanel somebody and I say, well, if I understand you have this important event that you have to go to, there's a way to deal with this. As far as security is concerned, that allows them to have the information that they need.
Now, we would like, if the court orders the release of the 15B to DOIS, we would ask for a stay to take it to 11-3. That said, I think this can be resolved. We don't have Cecily Reardon here representing DYS, but I think that her concerns can be resolved, and without turning over the 15B. So I'd ask the court to wait on this.
Well, I am going to wait on it, but my thought is that there's portions, there's having it read here without being released, there's ways to address the DYS concerns that doesn't require the report to be traveling out of here. But it's the first time it's been raised, so I want to think about that. But I also will be surprised if there's not a way to accommodate the concerns and have the issues sealed. The second issue is an evidentiary issue. And it's an evidentiary issue that has to do with what can be the basis for an expert's opinion. And that doesn't require release to anybody but the experts on criminal responsibility. So there's another issue that has to be briefed as well that's been raised relative to whether or not the basis for the expert's opinion can include suppressed statements. These are issues that are evidentiary issues and require briefing. So at this point in time, all I can say is that the competency 15B report doesn't have to be released to anybody, to be, other than the experts, to be part of an opinion. If it's allowed to be part of an opinion, it just wouldn't come out on direct. But I'm not making any decision about whether or not the 15B can be part of a criminal responsibility opinion by the Commonwealth's expert or the defendant's expert. That's going to require a briefing, as would the other issue that I just raised. And I'll be prepared to hear that as soon as counsel's looked into it and address the issue. But the issue, just to sort of put a fine point on it, is that in order for an expert to rely on information not admitted in evidence, that information would have to be independently admissible under DYS versus Juvenile and Commonwealth versus Nardi. So the question is what is in the report, would it be otherwise independently admissible under Nardi and DYS versus a juvenile? If it wouldn't be, then it can't be part of the opinion. And if it can be, absent some other reason, be independently admissible, then absent some other reason, it could be part of the opinion. So that's the legal issue that will need to be addressed. All right, so we're going to make some calls, and I'll just, I want to take counsel's view into this as well. I'm going to hear what the jury commissioner has to say, and then decide whether we continue tomorrow or Friday. But whatever day we continue today, there are a stack of questionnaires. And I believe that in that stack of questionnaires, even with my cautious non-advocacy eye, there are many prospective jurors who can be excused for cause and just receive an email. There's a way to deal with this. As far as security is concerned, that allows them to have the information that they need.
Now, we would like, if the court orders the release of the 15B to DYS, we would ask for a stay to take it to 1103. That said, I think this can be resolved. We don't have Cecily Reardon here representing DYS, but I think that her concerns can be resolved, and without turning over the 15B. So I'd ask the court to wait on this.
Well, I am going to wait on it, but my thought is that there's portions, there's having it read here without being released, there's ways to address the DYS concerns that doesn't require the report to be traveling out of here. But it's the first time it's been raised, so I want to think about that. But I also will be surprised if there's not a way to accommodate the concerns and have the issues here. The second issue is an evidentiary issue. And it's an evidentiary issue that has to do with what can be the basis for an expert's opinion. And that doesn't require release to anybody but the experts on criminal responsibility. So there's another issue that has to be briefed as well that's been raised relative to whether or not the basis for the expert's opinion can include suppressed statements. These are issues that are evidentiary issues and require briefing. So at this point in time, all I can say is that the Competency 15B report doesn't have to be released to anybody to be, other than the experts, to be part of an opinion, if it's allowed to be part of an opinion. It just wouldn't come out on direct. But I'm not making any decision about whether or not the 15B can be part of a criminal responsibility opinion by the Commonwealth's expert or the defendant's expert. That's going to require a briefing, as would the other issue that I just raised. And I'll be prepared to hear that as soon as counsel's looked into it and addressed the issue. But the issue, just to sort of put a fine point on it, is that in order for an expert to rely on information not admitted in evidence, that information would have to be independently admissible under DYS versus Juvenile and Commonwealth versus Nardi. So the question is what is in the report, would it be otherwise independently admissible under Nardi and DYS versus a juvenile? If it wouldn't be, then it can't be part of the opinion. And if it can be, absent some other reason, be independently admissible, then absent some other reason, it could be part of the opinion. So that's the legal issue that will need to be addressed. All right, so we're going to make some calls, and I'll just, I want to take counsel's view into this as well. I'm going to hear what the jury commissioner has to say, and then decide whether we continue tomorrow or Friday. But whatever day we continue today, there are a stack of questionnaires. And I believe that in that stack of questionnaires, even with my cautious non-advocacy eye, there are many prospective jurors who can be excused for cause and just receive an email